Now let's talk about what happens during cross-examination. I want to talk about what happens during, and this is just a simple list of do's and don'ts. And I like to start with the don'ts, right? If you remember anything, remember, don't do this stuff. If you get the do's, then it's frosting, right? So don't do this thing. For your witness, don't. For your witness, right? Answer just the questions posed. Same exact thing. It looks defensive. It looks like you're worried about the way the examination is going. If the question calls for a yes, give it to them. Do not try to offer explanations even when it's clear. Same thing with don't argue with the questioner. There's nothing that looks worse than when you are in this discussion and you're like, well, maybe that's the way you would say it, but I wouldn't say it, right? We've all seen people like that. We're in law school, so obviously there's people even in our sections that are like that, right? We know people don't like that person, so don't have your witness be that person on the stand, right? So that's what you want. Don't argue, don't answer more. Do not look at me for help. I say this to every witness and I say it repeated times. There's nothing that looks worse in a jury. One, I can't do anything for you. When you looked at me, guess what? The whole rest of the courtroom looked at me too. The judge looked at me, the whole jury looked at me. So that's the last time I'm going to start nodding or doing stuff like that, even though stupid attorneys do that, right? So I can't help you, so don't look at me. It looks like you don't have the answer. You do have the answer, answer it. I'm not going to be able to help you. If I could help you, I would be standing up and objecting. If I'm sitting down, don't look at me. Matter of fact, when I stand up, don't look at me. Any point during your cross-examination whatsoever, don't look at me. I cannot help you. Don't look at me. For you, this is what you shouldn't do. I can't tell you how many attorneys themselves react negatively during cross-examination. You've communicated effectively to your witness to do it the right way. They're answering the questions. They're measured, they're giving yeses, they're pausing, they got their game face on even, and guess what? The attorney's over there acting like a fool and sighing and gasping and putting his hands on his head and pulling out her hair. You as the attorney can't be reacting and all of a sudden pulling yourself into an examination and a process of trial that you're not involved, right? Let the witness handle it. And if things need to be done, if repairs need to be made, then do it on redirect and do it confidently and calmly, so you communicate to your jury that it was not a big deal what happened in cross, no matter how long it went on. So there are some immature, that's what they are, immature things that happen at counsel's table when your witness is on a stand. Don't do anything that looks like signaling, no matter what, right? You cannot shake your head, you can't nod, you can't hope the answer really hard in your face, you cannot do those things. They get put on the record and it is a bad day in court as a trial attorney to have the judge or another attorney in court say, counsel was shaking their head yes. Counsel was nodding along. Counsel touched their earlobe. You're not a third base coach. Don't do any signaling whatsoever when your witness is on cross. What should we do? For your witness, make sure they understand that they are talking to the jury. I don't care that it's supposed to be yes questions. I don't care that it's jammed down your throat leading questions. Make them hear the question, take a pause just like we do and we train them to do on direct. Take a long pause, turn to the jury and talk to them. So even if it's 58 yeses in a row, it should be hearing the question, pausing, yes, returning. Don't let them build up momentum by yes, 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 right? I don't want it to adopt the pace of the questioner. I want them to take time. Why else do I want them to take a pause, take a second in between the question and the answer? For objections, right? I want to have the room to object. If you're answering with a millisecond right after and they're launching into the next question, there's no opportunity for me to evaluate and object. I need space built in. You as my witness know, I don't care how loud, how angry, how confrontational, or how fast they ask questions, you, after the question mark, take a second, turn to the jury, then answer. Right? So you can prep your witnesses to do that. Even if you can't get at the content, you can prep their witnesses to do that. Pause after each question, understand the question first. A lot of times the bad news that happens in cross-examination is because a witness is nervous and answering and they're not sure what the question was. They're unsure of even the question and what it meant and what was posed to them, but they're saying yes because they just said yes 53 times in a row. We have to make sure our witnesses don't do that. A perfectly acceptable, in fact encouraged answer on cross-examination is I don't understand, or could you rephrase? I'm not sure I understand what you mean. Those are acceptable. Guess what? If you don't understand what you mean, the only truthful answer is I don't understand what you mean. So that's the way you have to coach them, the way you have to talk about preparing them for cross-examination. Make sure you are precisely on board with what that question was before you answer it. Make them clarify questions that are not clear in the beginning. Answer just the question. Calls for yeses, say yes, don't get defensive. And I say entirely because there's a lot of tactics, and you folks have seen them from the movies and from TV, right? I'm going to ask you a series of questions on cross-examination. They only call for a yes or no answer, and I don't want to hear anything else. An attorney doesn't have the authority to do that in court. There's no rule of process or procedure or evidence that lets them do that. So you make sure you prepare your witness, right, to answer questions fully. You know, you went home right after work, right? They want a yes, but the fact is you didn't go home right after work. You actually stopped and got gas, stopped at the store, and then went home. It's probably the same thing as what they're asking, but the answer is yes, but, or no, but. And there's an explanation involved. Don't let them confine you when that is misleading. So what I like to say to my witnesses, make sure you answer the question entirely, right? And if you can't, and they're confining you, and the judge for some reason is going along with it, that's a no. No, I didn't go straight home, right? You ask entirely. And if they have a yes, but, and something to say, and the opposing attorney that day wants to jump on top of them, you've seen this in the movies and TV too, I get no, but, and then the attorney jumps in and walks over, that's the point when I can protect you. That's the point where I, as the attorney, can help out. Do not ever, as the witness, as the attorney sitting there, let the attorney stop your witness from answering. You stand up, you object, and you say, may the witness be allowed to finish their answer. And almost every court, even the ones on the internet and checking email, almost every court will let the witness finish. Almost every court will uphold the rules of decorum where they'll say, one person's talking, wait till they're done talking, and let them go. You have very few courts that now will for some reason want sort of false, short, misleading answers. So have them answer accurately, answer entirely, and defend their right to say everything that's on their mind.